Thanks a lot. I think standing here, I feel rather like Mark Antony, trying to justify why he has anything worthwhile to say after the Honorable Bruchas had spoken. I think the problem that RISA and many other stakeholders in the music and literary rights industries have with the bill is the fact that it appears that no thorough assessment and interrogation of the impact that many of the proposed amendments shall have on the effectiveness of these organizations in carrying out their duties was done. We are aware that there's this socioeconomic impact study that was done regarding the soundness of the proposed amendments. This report was, however, not made public with the bill when it was published, nor were many stakeholders involved in the music and literary industries interviewed to determine the possible impact of the bill on their operations before the bill was submitted to Parliament. We also observe in the bill that often provisions from or based on other jurisdictions or treaty law have been incorporated without thoroughly assessing what the impact will be for the local industries, and often without also incorporating the safeguards used in such jurisdictions or in such treaty laws to lessen the harsh effects of such provisions. I'm just going to mention a few examples in that regard. In a number of amendments in the bill, Section 6, Section 7, Section 8, Section 9A, it is categorically stated that when a royalty is paid from the use of a copyright work, a user shall share in that royalty, has to share in that royalty. Now, that really is something that is confusing in the sense that the user is the party that has to use the work and has to pay a royalty for the use of the work. Why then should the user also share, be required to share in the royalty? Clause 7 of the bill, thankfully, introduces a new Section E under Section 9 of the Act, which introduces the right of communication to the public. However, following the examples in the introduction of this right under Section 6, 7, and 8, this communication right is coupled with the making available right, and I'll indicate why that is a problem. It is not a problem coupling the making available right with the communication right in respect of authors' rights, in respect of the Section 6 rights, Section 7 rights, Section 8 rights. But it is a problem if you couple the making available right with the communication right in respect of the Section 9 sound recording rights. This is because under the WPPT, WIPO Performances and Phonograms Treaty, from which these concepts emanate, the making available right is treated differently from the communication right in that treaty. The treaty deals with the making available right in Section 10 and in Section 14, and that right is an exclusive right. The communication to the public right is dealt with in Section 15. It is a remuneration right, or what we call here in South Africa, the needle time right. Now, the problem with coupling that together is that it will then reduce the making available right, which is an exclusive right, into a remuneration right. It will subject it to the needle time regime, which it should not form part of. And we urge that that should be looked at. Another issue relates to the whole issue of a separate right of public performance under the Section 9 rights. Because the new communication right is clearly a right that applies in the digital space, there should be a separate public performance right in the same manner as there is under Section 6. And this issue was canvassed with the policymakers on several occasions, and there was an undertaking that it would be included in the final version, and it has not been included. There is also the issue of the fact that under the WIPO copyright internet treaties, WPPT and WCT, there is a unique distribution right that those treaties deal with, which has not been incorporated under the amendments. With the changes proposed to Section 9A, there is a need to revisit the making available right in order to ensure that it conforms with the WPPT. Further to that, we remain concerned and perturbed by the amendment to Section 12 of the Act through the introduction of a fair use defense. I know that there has been arguments to the fact that fair use and fair dealing are the same thing, but we actually beg to differ in that regard. I think that it's very clear that fair dealing relates to specific cases, whereas fair use is a general criterion. But what we are mainly concerned with here is the fact that the fair use defense has been incorporated into South African copyright law without incorporating measures to ameliorate the harsh effects of such provisions for rights holders. For example, in rich jurisdictions like the EU, Australia, and even more liberal Canada, we see that there's an introduction of a private copy levy to try and ameliorate the harsh effects of, you know, such provisions of extension of limitations and exceptions. Also, there are other measures that have been taken, including in Canada, to ameliorate the harsh effects of these exceptions, such as an amendment that creates or imposes upon the defendant, you know, the onus to prove that copyright did not subsist in a work, rather than imposing it on the rights holder to prove that the copyright subsisted in a work. In other words, presumptions for the existence of copyright and authorship in a work, which have not been done here. If you are going to extend exceptions and limitations in that manner, at least give rights holders, you know, that should be able to say we can take a case to court and the onus of proving that there was an infringement will be on the defendant, not on the copyright owner. The proposed new Section 12B introduces the most extensive form of a US-style first sale doctrine in the nature of international exhaustion, without even putting in measures incorporated in the US Copyright Act itself to ameliorate the harsh effects of this doctrine. For example, in the US, the rental of sound recordings and certain usages relating to computers are excluded from the application of the first sale doctrine. Without such specific exclusions in the proposed amendments, the importation of copyright works that were published without the authorization of copyright owners elsewhere in foreign countries would be lawful here in South Africa. And it would be, for example, also be lawful to open a video and sound recording rental shop without paying any compensation to the rights holders. The proposed Section 13A, which was referred to, introduces a provision permitting temporary reproductions of transient or incidental copies, mimicking the provisions of Article 5 of the EU Information Society Directive, without, however, also incorporating the provision of paragraph 5 of that article, which subjects the application of that provision to the three-step test. So that is one of the problems we are highlighting. With regard to the proposed amendment to Section 5 of the Act, which provides that copyright in works funded by the state or an international or local organization shall vest in those entities, I understand that we might have lost something in translation, but I wanted to highlight the fact that did it occur to the drafters that Section 21 of the current Act, which links to the provisions of Section 5, specifically excludes certain works from the application of that section. So in particular, musical and literary works are included, which means that currently persons commissioned by the likes of the SABC to compose jingles, signature tunes, and the like would still own copyright in those works and thus continue to earn royalties from SAMRO, Capasso, and other similar organizations. But what the bill introduces now would mean that they will not be entitled to earn any royalties from Capasso, SAMRO, and the likes because they don't own copyright in those works. And then again, we fail to understand why in one national legislation it is permissible that works that are funded, intellectual property funded by the state, like the Intellectual Property Act in relation to the funding of, research from publicly funded works and all that, the copyright clearly in those cases vests in those institutions. It doesn't vest in the state. Why should it be different when it comes to authors, artists, and rights holders? And then lastly, did it also occur that to the drafters that the effect of the proposed amendments to Section 5 is that producers of films funded by the state, by the IDC and VF, such as Tsotsi Yesterday and similar films would no longer own copyright in those films. How will those filmmakers be able to attract other investors to assist with making the film and securing distribution for the film if the producer does not own copyright in the film and thus cannot give any equity to those investors? And how will international filmmakers want to continue collaborating with South African filmmakers under such circumstances? This, we submit, will signal the demise of the fledgling South African film industry. Thank you.